Greetings. I'm Amy Southerden, Assistant Director at the Center for the Study of Canada and Institute on Quebec Studies at SUNY Plattsburgh, and I am delighted to welcome you to the second session of the virtual Conversations on Canada Spring 2021 series. Conversations on Canada webinar series is organized by the Center for the Study of Canada and Institute on Quebec Studies at the State University of New York College at Plattsburgh, a U.S. Department of Education Title VI National Resource Center on Canada with additional support from the Quebec Ministry of International Relations and La Francophonie. The Conversations on Canada series addresses current issues central to a fuller understanding of Canadian studies. So far, we have offered 4 sessions, including first, why is Donald Trump mad at Canada? Understanding American foreign policy toward Canada. Second, the pandemic experience. How do Canada and the US compare? Third, the Black experience in Canada, race, the state, and the persistence of social inequality. Fourth, home and native land, reconciling experiential Canadas. Recordings of these past presentations are publicly available on YouTube in case you missed them, or if you wish to reference them again, please do visit tinyurl.com/conversations on Canada. Thank you to our virtual audience for your interest to join us today for this conversation on Canada titled, What If the US Had Canada's Notwithstanding Clause? Constitutional Lessons from the North. We are grateful for participation from SUNY Plattsburgh students, faculty, staff, and alumni, business people of our New York, North Country, region, and beyond, as well as scholarly members of the Association for Canadian Studies in the United States. We hope you are all doing well and having a good day that's only getting better. During this webinar, to engage with our speakers, if you have any questions or comments, please do submit them in the Q&A box on your screen. We ask that the questions or comments you have, again, be submitted in the Q&A box. At this time, it's my pleasure to introduce you to Dr. Christopher Kirky, Director of the Center for the Study of Canada and Institute on Quebec Studies at the State University of New York College at Plattsburgh, and President of the Association for Canadian Studies in the United States.
Thank you, Amy. Thank you, everyone, for joining us again this afternoon for one of our conversations on Canada. As Amy suggests, we're moving along very well this academic semester and academic year, and we're delighted to have Kevin McMahon from Trinity College join us this afternoon. As Amy suggested, his talk is going to be a comparative lesson, comparative focus on constitutional construction and constitutional understandings. I'm going to read to you quickly a brief description of Kevin's overall talk, and that is he draws on Canada's Charter of Human Rights and Freedoms, including a weird kind of provision, something called the Notwithstanding Clause, that effectively empowers the federal parliament and provincial legislatures to, in effect, ignore a ruling from Canada's Supreme Court. And this is a concept he's going to suggest this afternoon that is decidedly and largely foreign to the United States. But it also begs the question, what if the United States had such a clause in its constitution? He's going to consider that idea and in the process explore Canada's constitutional politics today. Kevin, as I mentioned a moment ago, is at Trinity College. He's the John Reitemeyer Professor of Political Science and Director of the Graduate Program in Public Policy. He's written a lot of good stuff, is a simple way to put it, but he's done 2 fabulous, well-recognized and award-winning books on the American presidency and the political origins and consequences of Supreme Court decisions, most notably under the administration of Franklin Roosevelt and Richard Nixon. Kevin's no stranger to Canada. Most obviously, he spent a semester at the University of Montreal as a Fulbright Distinguished Research Chair. He's been, a good friend to the Center for the Study of Canada, and my best friend for a long time. So without any further ado, I'm pleased to turn it over to Kevin so he can talk about this sort of comparative framework for us to consider. Kev, it's all yours.
Thanks, Chris. I appreciate it. Thanks, Amy. I'm glad to be here. I wish I were actually in Plattsburgh, but you know, things are strange these days. I've spent a lot of time in upstate New York, originally from the Albany area, and I went to undergraduate at SUNY Potsdam, which is not too far from you. And as you can see, I'm a Bills fan, the only team in New York State. Okay, so I'm gonna share my screen here, and I have a few slides to use to reference. So hopefully that will be helpful for you. So as you can see, the title of the talk, as Chris mentioned, is what if the US, the United States, had Canada's Notwithstanding Clause, Constitutional Lessons from the North. So let me sort of give you some background about why there are concerns about the role that a Supreme Court in the United States or courts generally play in a democracy. And in the US, the phrase that's often brought up is something called the counter-majoritarian difficulty. I know that's a big phrase, so let's break that down a little bit. So what we mean by that is when the court makes a ruling, when the court decides to strike down a piece of state legislation passed in the state legislature or national legislation passed by the US Congress and signed by the president, it is acting counter to the majority, right? The majority of state legislators in, let's say, Connecticut passed the bill. It was signed by the governor, and the Supreme Court, the justices said, no, what you declared as constitutional, what you thought was constitutional is not. And we get to decide that it isn't, right? That it's null and void. That this is the exercise of judicial review, and therefore it raises questions about how much of a democracy do we have, right? As I have here, it's at the center, this idea of the court acting in conflict with the majority is at the center of complaints about the court's action in the first part of the 20th century from the left, from liberals, and in the second part of the 20th century and continuing to today from those on the right, conservatives. Two examples, Franklin Roosevelt. Franklin Roosevelt is elected by a very wide margin in 1932. He has overwhelming majorities in the US Congress. He passes his New Deal program to try to revive the economy in the midst of the Great Depression. And the court strikes down key pieces of that legislation, declaring it unconstitutional. So Roosevelt, when he's reelected, again, the largest presidential election in terms of the result in the history of the presidency up to that time, over 60% of the vote, 46 of the 48 states. Democrats control about 80% of the Congress in both the House and the Senate. He's arguing that the court is limiting his ability to try to get things done, right? It's limiting, it's handcuffing the majority. And he proposes something called the court packing plan, which ultimately is defeated. But you understand this concern, right? That the court of unelected 9 wise men at the time in 1930s, today wise men and women, most of whom we would have difficulty naming, right? I often say to my students, most baseball fans would have an easier time naming the 9 starting players on their baseball team than the 9 justices on the Supreme Court, right? So we know little about these individuals, but they are very powerful and they serve for a very long time, right? We know that they're often chosen at a very young age so that they could serve for a very long time. The other example from a conservative standpoint is the decision of 1973, Roe versus Wade, which gave women a right to terminate an unwanted pregnancy. Really, since that decision, it has become a rallying cry, or overturning Roe has become a rallying cry for conservatives, and has really been a centerpiece of Republican strategies to win the presidency and transform the court, right? So again, what did Roe do? Roe said that for all those states that had laws banning abortion, and the Roe case comes out of Texas, but for all those states that had laws that were in conflict with this decision, they were now null and void, right? The court made a determination, right, that whatever was in that opinion, this trimester system that they created, was now the law of the land. So very focused at the center of power in Washington, and obviously at the court itself. Now this comes from the idea of constitutional supremacy. As you know, I know you all know, the US has this system of constitutional supremacy, right? The Constitution is supreme. If a law is passed that is in conflict with that, with a component of the Constitution, the Constitution wins out, right? The Constitution rules the day. But more significantly, since Marbury versus Madison, the court has had the ability to say what the law is, right? So not only is it that there's a conflict with the Constitution wins, but the judiciary makes this determination, not the presidency, not the US Congress, right? And, you know, despite the fact that this wasn't really clear at the time of the founding, and, you know, the president swears to uphold the same Constitution that the justices do. The members of the US House, the member of the US Senate, they swear to uphold the same Constitution as well. But we've developed a system that many would call judicial supremacy, right? That the court gets to decide what the law is. Now, it's a little more complicated than that, certainly. But for the purposes of today, let's keep that in mind. Right, so this helps explain why the judiciary has become a centerpiece of US politics. So let's just take a look at one exit poll from 2016, right? So Donald Trump, obviously running against Hillary Clinton. This question was asked: in your vote, were Supreme Court appointments the most important factor, an important factor, a minor factor, or not a factor at all? And what you see here is that 21% of voters, more than a fifth of the voters, said this was the most important factor in determining their vote. And as you see here, Donald Trump had a significant lead over Hillary Clinton among these voters. And in fact, when Donald Trump, soon after he was inaugurated into the presidency, introduced Neil Gorsuch to replace Justice Scalia, who had died the previous February. He said millions of voters had gone to the polls to elect him because of this issue, right? Because of this court issue. So he even highlights the importance of this issue in helping him win the presidency. And if you break it down in the various states that were so important to his election, Pennsylvania, those three deciding states in particular, Michigan, Pennsylvania, Wisconsin, you can show, certainly in Michigan and Wisconsin, how important this issue was in these very narrow races. If you look at this same figure, by the way, in 2020, it's less important. And that's in part because Donald Trump was able to name 3 justices to the Supreme Court, which is extraordinarily lucky. It's it's very rare for a president to name 3 justices in a single term, right? If you think about Barack Obama named 2, George W. Bush named 2, both in 8 years. Bill Clinton named 2 in 8 years. The last president to name 3, and he named 4 in his first term, was Richard Nixon. So, but it shows you how significant the court is in American politics. Okay, let's. This becomes even more important in a polarized age, which we obviously have today. And it really raises the court's legitimacy, or questions the court's legitimacy in a democracy. Why would we question the court's legitimacy? Well, again, the court, even if we don't talk about parties at all, the court sits in this place, as I discussed earlier, as this counter-majoritarian institution. But what do we have now that even highlights this problem? The Democratic nominee has won the popular vote in 7 of the last 8 presidential elections. From 1992 to 2020, the only time the Republican won the popular vote was in 2004, George W. Bush. And that he won very narrowly. The Republican nominee has won the electoral vote in 5 of those, yet, I'm sorry, the Democrats won it in 5 of those 9, yet 6 of the 9 justices have been appointed by Republican nominees. And this is a very young court by historical standards. Clarence Thomas, for example, is, let's see, 72 years old now, I believe. He is 15 years younger than Ruth Bader Ginsburg was. And as you know, she just died last fall, right? So the expectation is that the court, this court of 6 conservatives, and some are more conservative than others, will serve for a very long time. And this Republican appointed majority will have a control over where the court goes. Add to the fact that a majority of these justices are what I call minority justices. And what I mean by that is these are justices confirmed by a majority of senators. But if you collect the votes of all those senators in their most recent election, they do not total up more than those opposing the justice. So one example, Brett Kavanaugh, right? Brett Kavanaugh was opposed by 48 senators, all Democrats. They earned 24.5 million more votes in their most recent election than the 50 senators, all but one Republican, who supported him. That's a 59 to 41% difference, right? So not only do you have a president, Donald Trump, who did not win the popular vote, you have a Senate which does not represent even close a majority of the voters in the most recent election, right? So does this raise new questions about the court's role in a democracy? Now, because of this, we heard talk during the campaign of what the Democrats would do if they would get elected. And we had heard talk back similar to the talk we heard in the 1930s of a court packing plan, of a plan to expand the size of the court, currently 9 members and has been 9 members for about 150 years. Because of this conservative lock on the court that's likely to exist for at least a decade, should the Democrats try to expand the court, to take it back, right? This is a very unpopular proposal. It was even in the 1930s when Roosevelt had all that support. But nevertheless, progressives in particular are scratching their heads about what to do. So with that in mind, let's look to Canada, because Canada takes a much different approach. And it's an interesting way to sort of think about both this constitutional politics in Canada and how we might learn a lesson from Canada. Canada, as you know, does not have constitutional supremacy, but has parliamentary supremacy with a constitution, right? So it's this balancing act of both parliamentary powers and the powers of the Constitution. And included in the weapons might be too strong of a word, but the powers, the authority of both the provincial legislatures and the national legislature is this notwithstanding clause. So as Professor Kirky suggested at the beginning, it provides the democratically elected federal parliament and the provincial legislatures the power to override a decision of the Supreme Court of Canada without the aid of a constitutional amendment, right? We know in the United States that you can certainly amend the Constitution if you want to, or change the court. Changing the court takes a very long time, but it's also very difficult to change the Constitution via amendment. We've had 27 amendments to the Constitution in the United States. 10 of those were passed immediately as the Bill of Rights. That means we've had 17 in over 200 years, 200 plus years, 30, almost 30 years. 2 of those cancel each other out, dealing with prohibition, so that's 15. 3 of them are basically the result of the Civil War, 13, 14, and 15. Some are quite technical, like the most recent one, Amendment number 27, which deals with congressional pay. So you see this difficulty, right? So how do you change this Constitution in a democracy? Additionally, it's important to know that the Notwithstanding Clause has 2 restrictions. One, it cannot be used against democratic rights, such as the right to vote or the mobility and language rights. And second, an override expires after 5 years unless reenacted by the legislature. Now, I think that second one is important to focus on. The first one is obviously important, right? An act to undermine voting rights. The second one seems less important, but it actually is highly significant because it requires new majorities to reaffirm the decision of a provincial legislature or the parliament at every 5 years, right? It's not something that's just in place and we forget about it, right? It requires a reaffirmation, a new democratic majority elected by the people to express once again a desire to have a law that's in conflict with a decision of the Supreme Court of Canada. Okay, so it is a form, I would certainly argue, of popular constitutionalism. And this is the idea that the judges and justices should not be the final arbiters of what the Constitution means. If we think about the judges and the justices, as I said earlier, they are far removed from American democracy. We don't know them very well. We don't hear them very often. Most of the ways in which the justices communicate is through their opinions, many of which are difficult to read, and few people read them, right? The court has also become much more of a cloistered institution. It once was common for presidents to choose sitting senators, former governors, members of their administration, right? Individuals who are active in politics for the court. Perhaps one of the great justices, chief justices of the Supreme Court in the 20th century, Earl Warren, was a governor of California, right? He was active in politics. Today, we don't have those type of individuals who are chosen. Before Amy Coney Barrett was selected in October of last year, I used to say, you could go to any law school you wanted if you wanted to be a Supreme Court justice, as long as it was Harvard or Yale, right? Because all the justices at that time had gone to either Harvard or Yale Law School. And that's a fairly recent phenomenon. Certainly, former justices had attended those institutions, but not all of them. And it's become this sort of, there's a clear path, particularly on the Republican side, of what you have to do to become a Supreme Court justice. You know, it's not a happenstance that all the 6 sitting justices appointed by Republicans are Catholic or have a past affiliation with Catholicism. 5 of them identify as Catholic, and Neil Gorsuch has past affiliations with Catholicism. Most of them are former Supreme Court clerks. They clerked for conservative justices when they served at the court in this capacity. So most of them, or all of them, all the 6, had extensive experience in Washington, D.C. and in a Republican administration, right? And we can get into reasons of why that's the case, why there's this sort of checklist if you want to be chosen for the court. But nevertheless, that's certainly very important. And, you know, that further removes the idea of constitutional, it's further removed from the idea of popular constitutionalism. Now, with regard to the Notwithstanding Clause, for many years, it was not used. And this was sort of a question that Professor Kirky mentioned. I spent the semester at the University of Montreal under the Fulbright program. And that was sort of the question that I was looking at, and this was in 2005, 2006. You know, why was the Notwithstanding Clause almost a so-called dead letter law, right? That it wasn't very used. It wasn't used very frequently. But since 2018, there have been a number of notable cases of its use. And the most noteworthy one is Quebec's Bill 21, which banned certain public officials from wearing religious symbols such as crosses, hijabs, turbans, and yarmulkes. And we can get into the validity of that law, but and if you think about it from the aspects of the United States, if such a law were passed by a state, this would be a decision by the Supreme Court, right? This would be appealed. This would go to the Supreme Court. The justices would rule. Maybe it'd be 5-4. Maybe it'd be a unanimous decision. But that's where it would go. What the Notwithstanding Clause allows is basically for Quebec to say, notwithstanding what the Supreme Court of Canada has said, this law is going to be in place in this province, right? That the government in Quebec is going to stand by the law, right? Now we might raise concerns about that, right? Obviously, this law has been criticized for suppressing the wishes and the religious requirements minority groups, of religious minorities, you know, suppressing the rights of the right to free exercise of religion. But again, it's this tension between democracy and judicial action. So back to the question that I started with: what if the U.S. had such a clause in its constitution? One, I'd say there are two conclusions. If you consider the case of abortion, which is certainly the most important with regard to political salience, right? The importance within voting decisions. You see, this is a map of the views on abortion in all the 50 states. So the bluer states are more pro-choice, right? More supportive of Roe versus Wade. And the redder states are more pro-life, more interested in overturning Roe versus Wade. Not too surprising, right? The conservative states in the South are more red. Those in the Northeast are more blue. Pacific Coast blue as well. Some unusual states. Alaska is a pretty red state, but has this libertarian streak, and it doesn't want the government, you know, having such a role in the lives of women. But what you would see if that were the case is you'd see a lot more constitutional lawmaking at the state level, right? That it wouldn't be this decision by the justices in Washington controlling what's happening in places like Texas or Louisiana or Alabama or Mississippi, right? It would be up to the states to say, you know, if we want this or not. And because it has that 5-year sunset provision, it requires a changing state, a state that's going through change. For example, Virginia is a state that has recently gone basically from a solid red state to now a solid blue state. It would allow for those states to change over time as well. So, you know, that's an interesting point if we're thinking about constitutional lawmaking. And I think the second thing that would certainly be in place is the importance of the court itself would be lessened, right? That we would be less worried about, you know, whether Ruth Bader Ginsburg was going to live until the next election, who went to the right school, or who, you know, is somebody a thoroughly conservative justice, and, you know, should we appoint somebody who, like Amy Coney Barrett, is 48 years old because she can serve for a very long time, right? These types of questions, and the nature of the hostile nature of the nomination process would be lessened, because there would be other outlets for constitutional lawmaking. And this is just an example at the state level. It could occur at the federal level too, at the federal legislature, you know, meaning the U.S. Congress. So, so that's pretty much my take on if the U.S. would have had Canada's notwithstanding clause. Thank you. Chris, you're on mute.
Thank you, Kevin, very much. Appreciate your observations this afternoon, providing this nice detailed distinction between two advanced liberal democracies that share, along with Mexico, of course, the North American continent, but have approached the issue of ultimate you know, legality and constitutional decision making in different ways, and because it's clear they have. So right now, folks, what I'm going to do is, if you have any questions, please send them into the Q&A, and I'll be glad to send them along to Kevin. I'll just moderate a conversation here with us. Can you spend, Kevin, if you can stretch back? Clearly, this has, as you pointed out, especially with the abortion issue, some very different political ramifications for how states decide to, in the United States context, to proceed with regard to challenges and legislative initiatives. And, knowing that sort of the buck stops not with them because they don't have the right to invoke a notwithstanding clause, but instead can proceed all the way up to the Supreme Court. Having said that, you also pointed out, I think it's important for folks to know. So, I think our students joining us today know that Canada's been around since 1867, but the Canadian Constitution and the Charter of Freedom and of Human Rights and Freedoms didn't come about till 1982. It was a bit disjointed. That would take a semester long to explain, quite honestly. But the fact is that when the Notwithstanding Clause was introduced into Canada's Charter of Human Rights and Freedoms in 1982, it was done so for very political reasons. And Kevin, I'm just wondering did you want to take a moment to explain how this came about, or why it was introduced, or what the political origins of it were? Because it seems to be such an odd duck. It seems to the fact that it politically allows, provincial legislatures to sort of say, okay, we appreciate what the Canadian Constitution and the Charter of Rights and Freedoms states, but, we've decided we're not going to follow. So,
yeah, I mean, as I understand, this has been a while since I've written on it, but as I understand, it was a compromise, right? A compromise from then Prime Minister Trudeau, who, and a sense that provincial legislatures in particular should be given a little more authority
right,
than they might have, if there were not a notwithstanding clause.
right. No, I think that's exactly the case. I think it's shown to be very well that as the Prime Minister was trying to repatriate the Canadian Constitution and strike this Charter of Rights and Freedoms, that there was a concern that, the judiciary would have too much power, and that provincial legislatures would be, apart from the Canadian sharing of powers under the Constitution and the 1867 British North America Act, that they would have even less so. So there was a need to keep that in check. What do you mentioned, Kevin, an important observation that since 2018 we've seen a spike. I want to say a little bit about why that is the case, a little bit more in terms of...
that's a good question. When I wrote the piece back in 2007, 2008, I forget specifically when, and at that point I was sort of exploring the opposite, right? Why it hadn't been used all that much, and certainly in at that time point. And my argument then was that you sort of had constitutional, no matter the party, right, that the parties were largely in agreement on sort of these what role the notwithstanding clause would play, right? Because you can imagine it takes sort of somebody who's swimming against the current, right? It takes somebody who's outside the mainstream to say, wait a second, I'm not going to go along with sort of the conventional wisdom on this policy or that policy. I'm not going to just sit back and allow the Supreme Court of Canada to undermine all my hard work, right? Because I think this is a good idea. So I think, I talked at the time, I wrote about the political regime, and that the political regime was represented both in the Parliament. Sort of the governing regime was both represented in the Parliament, and the justices at the time were connected to that, right? So critiquing the justices in such a way would represent almost a critique of itself, if you will. And I think what you see in these most recent examples is you have more of a populist politicians who are, very much like Donald Trump in the United States, who are eager to say they're different from what's been going on in the past or the recent past, right? Who want to take, certainly in the case of Bill 21, popular pieces of legislation that might be constitutionally questionable and say, you know, let's set aside our constitutional concerns because we think this is important, and we think it's constitutional, right? We think it's acceptable. So we're going to push back against, you know, sort of the mainstream, and we're going to pursue our own idea. And that's happened in, you know, both in Ontario, in Saskatchewan, New Brunswick, I guess is a newer case dealing with vaccines, which is interesting. But most notably in Quebec.
It's fascinating because, as you say, we've had this run of recent cases, and quite honestly, when you think about the ability of a province in Canada to invoke the Notwithstanding Clause, and you know, seeking that remedy or that option, if you will, and you reference Quebec's Bill 21 and so on and so forth. The fact is, one could think about that if you know, if we're experiencing, as we are, an uptick in the usage of the Notwithstanding Clause, that could prove. What are your thoughts, Kevin? Do you think it could prove to be, over the long term, to have a very corrosive effect on the Canadian political body? I mean, if you have essentially, you know, essentially what it allows, and correct me if I'm wrong, what it allows individual provinces to do is to basically, you know, set laws forth for their jurisdiction, for their provincial jurisdiction, in a way that may not be compatible with, complementary to, or consistent with the other 9 provinces on
Sure.
really important issues.
Yeah.
So, you know, I'm just curious what your thoughts are about the corrosive nature of that Notwithstanding Clause over time.
Yeah, no, I think, you know, I think its lack of use sort of suggested a almost a consensus, right? That even if we as a province disagreed with a decision, that taking the step of using the Notwithstanding Clause was a step too far, right? That we would seek other ways to exhibit our displeasure with a particular law, right? So, you know, once the barrier is broken, you can certainly see, you know, if we're sort of thinking out loud, the possibility that it gets used a bunch more, and just that you have, you know, at least groups of provinces acting in one way and other groups acting in a different way. I mean, you know, if we go back to the case of abortion in the United States, and this is the same thing. If Roe versus Wade were overturned, it doesn't mean abortion would be outlawed across the country. It means it would be dependent on the state. And then if you think about for the actual individuals affected by this law, right? If you're a woman, if you're a pregnant woman in Alabama, it's a much different issue than if you're a pregnant woman in New York. So it does, I totally agree with your suggestion that increase of use is likely to have a polarizing effect in Canada.
I think so. I really do, and not a positive impact, I would say.
Right.
One of our participants today is interested in knowing if you think, when you think about the Notwithstanding Clause and its use, what it allows individual provinces to do, can that be viewed as a lesson or a warning to the United States in some respects?
Yeah, I mean, I see it as a, you know, as I sort of presented in this talk, I mean, I see it as, because so much reliance on our constitutional politics is placed at the Supreme Court, you know, and literally we have state legislators and presidents and members of Congress who say, this isn't my area, right? Let the courts decide, right? they simply remove themselves from any consideration of the Constitution, right? That is,
Right.
it's not their job. So I think when individual legislators become engaged on these constitutional questions, I think that's better for democracy. So that's the positive side.
Right.
The negative side, obviously, is particularly for the rights of minorities, like in the case of Bill 21, right? Obviously, Quebec is arguing that this is they have concerns about the religious nature of certain symbols being displayed in public offices. You know, it's sort of akin, if for those, from a US example, it's sort of akin to prayer in school, right? That prayer in school used to be quite common. Then the Supreme Court said, well, the state can't require school children to attend school and then tell them that they have to say a prayer. It's called captive audience. So Quebec is sort of arguing something similar, that if somebody has a clearly religious symbol in terms of, a turban, for example, or yarmulke, or hijab is obviously the most, the centerpiece of this bill, or at least that's the allegation, that this is a targeting Islam, the Islam religion, and particularly women. They're saying that this is like prayer in school, right? You're sending a religious message through this symbol. But if you're the member of the minority group, this is a central component of your religion, displaying your religion. It's not, if you're a teacher, or I guess it's a principal, it's not that it's not like a safety issue, right? Which sometimes you can restrict headgear for religious headgear for safety issues. So what's the big deal, right? It seems like you're being targeted because because of your religion and the fact that it's a minority religion.
No, very true, very true. I'm going to throw a question out to you that speaks to the United States specifically, and one of our participants today is asking, how can progressives, and this is a tough question because both political, I think you can look at this, he's asking it, I assume, from a legal perspective, but you can also think of it from a political perspective, which might even be harder. But how can progressives do an end run around the so-called tyranny of the minority in the United States? What is there for them to do with regard? Do you think the idea of expanding the Supreme Court has any legs? And can you give us a sense of, what's happened since President Biden's come into office? We know that he called for a commission to report back to him within 180 days. Is there any realistic possibility that this might happen or not?
I don't, in terms of like packing the court, I don't think so. I mean, it's certainly constitutionally possible. It only requires an act of the Congress and the signature of the president. But, just like using the Notwithstanding Clause was sort of a bridge too far for Canada for many years. This packing of the court hasn't been done since the Lincoln administration, right? So even somebody as popular like Roosevelt wasn't able to get it done. And I think the real fear is that, well, the Democrats increase it to say 15, and then the Republicans get in and they increase it to 20, right? And it's just an undermine this institution that is consistently held as having the most respect in the United States compared to the presidency and compared to the Congress.
Right.
And you're undermining this historically significant institution. So I think it's quite difficult to do that. Now, what can progressives do? Well, I think DC statehood, and all the conversations around DC statehood are certainly driven by some of these concerns. if 500,000 progressives move to Wyoming, that might be helpful, right? I mean, the problem is progressives live in cities, and the U.S. Senate is not constructed, and really the Electoral College as well is not constructed in a way to reward dense living. So that would be a recommendation.
Yeah, we'll start moving to Wyoming tomorrow. Another question that's come up is when you think about, some commentators, scholars have observed over the last 15, 20 years that when they look at the role and place of the Supreme Court of Canada within the broader context of Canadian society, and they look at it, let's say since 1982, since the Charter of Human Rights and Freedoms, the Notwithstanding Clause, the Canadian Constitution has been in place, they note that there's a distinct change in the nature of the Canadian Supreme Court. And by that, I mean, it was sort of a staid kind of traditional legal form that it wasn't very engaged in shaping Canadian society and politics, some would argue. And by contrast now, what we're finding, particularly over the past 25 years or so, is a much more engaged Supreme Court, a much more activist, to use an American phrase in terms of studies of the court, activist court in terms of shaping Canadian society. What's your take on that?
Yeah, I mean, this is something that's that's going on, across the world, where which once was sort of an example that you might find in places like the United States, or India has historically had an activist court, Israel. You're now seeing it even in places which, at least by design, are based on the idea of legislative supremacy. So I think that's an important note to take. And it's also interesting because the way in which the court is constructed is much less political than let's say the United States, and the justices are forced to retire at 75, right? So you have an awareness, the public has an awareness, the parties, the party leaders have an awareness of when vacancies will be occurring, which is not the case in the United States. So you have this guessing game, like everyone, the guess now is, will Justice Breyer retire in June, right? And, so there are, in terms of, I find that interesting, because there are other proposals to constrain the Supreme Court in the United States that sort of are similar to what Canada has already done. So it may suggest that those possible reforms may not be as effective as some people would hope.
Yeah, I agree. I am going to just suggest one last question for this afternoon for Kevin to consider. And that is, moving forward, I would think, looking north again, that given this recent use of the Notwithstanding Clause, it seems to suggest, some might suggest, well, this may be a flash in the pan, because up to 2018, there really had been very just episodic use, and now it seems to be a regular occurrence. Question is, would you expect, and I know you need a crystal ball for this, because it's really driven by politics at a provincial level more than anything else, but would you expect that sort of now that dare I say, the genie's out of the bottle, and that this is being used with greater frequency, that we'll continue to see that going forward?
Yeah, I mean, I certainly would. And, it may depend on the consequences of those parties that have pass the notwithstanding clause within their individual provinces, right? So if they're punished at the polls, if there's some sort of type of backlash, perhaps you wouldn't see it, but you know, I think there are, certainly when I was writing back in, you know, about 10 years ago or so on this issue, I found it striking that this was sort of a tool in the toolbox that wasn't used, right?
Right.
And now that it's been used, and if it's, you know, if it's used in a way that's politically popular, and you know, if you have part of all discussions about the courts in general is this sort of this elitist idea, right?
Right.
That these are supposed to be the smart men and women. They, you know, they went to the fancy schools. They get to tell us what's going on and what the law is. And, you know, for a populist politician, you know, this is easy, right?
It is.
You know, it's a way to say, no, we get to decide, right? The
Right.
people get to decide, not you people in the fancy robes. And so I think, yeah, again, if it's seen as effective,
Right.
politically effective, I think you'll see much more of it.
Yeah, I think you hit on a very important point, which is to say that to the extent that a particular province is willing to pull the lever of the notwithstanding clause, you know, if it's on an issue that enjoys popular broad support within a province, they're going to feel safe in their ability to do that. And that's, I think, that correlation is very strong so far. We'll see how it goes in the future.
Sure.
Ladies and gentlemen, I want you to join me in thanking Dr. McMahon for his remarks today. Thank you, Kevin, very, very much. And I'm pleased to turn it over to Amy, who will bookend and conclude our conversation today. Amy, please.
Thank you, Chris and Kevin, for this very interesting conversation on Canada. And special thanks to our virtual audience participants and to our many supporters at SUNY Plattsburgh, the U.S. Department of Education, and the Quebec Ministry of International Relations and La Francophonie. At this time, we ask for your feedback on this session via the Zoom poll being presented on your screen. Please do join us for our next conversation on Canada, taking place April 26th at 2 p.m., titled, "Is the Special Relationship Back? Canada-U.S. Issues After 100 Days of Joe Biden," presented by Dr. Frédéric Gagnon. To register, please go to tinyurl.com/Canada Conversation April 26th. Also, please do check out our Conversations on Canada YouTube channel at tinyurl.com/Conversations on Canada. Again, tinyurl.com/Conversations on Canada. Thanks again for your time this afternoon and wishing you a pleasant rest of your day.